It was just past 6 in the evening when the sky began to soften into that quiet shade of blue that comes right before nightfall, the kind of hour when most people are heading home, thinking about dinner, maybe a phone call to a friend, or just a few minutes of peace after a long day. He was no different. Dressed in a pressed shirt and slacks, he drove carefully down the wide, tree-lined street on the edge of town, windows down, radio low, mind already unwinding from the day's work. He didn't see the patrol car until it was behind him, lights flashing. At first, he thought it must be for someone else. He checked his speed well under the limit. He'd signaled before changing lanes. He hadn't run a light or make a sudden turn, but the siren gave a short, sharp yelp, and he knew it was for him. He pulled over smoothly to the shoulder, turned off the engine, and placed both hands on the steering wheel where they could be seen. The officer who stepped out was tall, broad-shouldered, with a walk that carried more authority than necessary. He approached slowly, one hand resting near his belt, eyes scanning the car like it might spring a trap. When he reached the window, he didn't greet him. Didn't say good evening or ask how he was doing. Just stared for a beat too long before finally speaking. License and registration. He handed them over without a word, keeping his movements slow and deliberate. He'd been taught this early, how to behave during a stop, how to avoid giving anyone an excuse. Not because he'd done anything wrong, but because he knew from stories, from history, from lived experience, that sometimes just being who he was could be enough to turn a routine moment into something dangerous. The officer took the documents and walked back to his cruiser. 5 minutes passed, then 10. The air grew cooler. A few cars drove by, slowing slightly out of curiosity before speeding up again, eager to avoid getting involved. He stayed still, hands back on the wheel, eyes forward. Then the officer returned, but this time his tone had shifted. Sharper, accusing. "Step out of the vehicle." "Am I under arrest?" he asked calmly. "Just step out." He did as he was told, keeping his hands visible. The moment his foot touched the pavement, the officer's hand clamped onto his arm. Not gently, not like someone helping, like someone controlling. "Why are you resisting?" the officer barked, loud enough for anyone nearby to hear. "I'm not," he said, voice steady. "I'm doing exactly what you asked." But the officer kept talking, now into his radio. Suspect exited vehicle aggressively, refused commands, made furtive movements toward his waistband. None of it was true. Not a word. But it was being said and recorded, as if it were fact. Within minutes, backup arrived. Another officer, younger, watched silently as the first one pushed him against the hood of his own car, patted him down, then snapped cuffs on his wrists. No weapon was found. Nothing illegal in the car, just a man who'd been driving home after a long day. At the station, he asked for a lawyer. They gave him a public defender the next morning, a tired-looking man with too many cases and not enough time. "Look," the lawyer said, flipping through the file. "They're offering a deal. Plead to a misdemeanor, community service, and it's done. No record if you stay clean for a year." He shook his head. "I didn't do anything," the lawyer sighed. "Doesn't matter. Cops say you resisted. Dashcam might be corrupted. Body cam footage? Still processing. You know how this goes." But he did know how it went. And that was exactly why he couldn't take the deal, because if he did, it would mean accepting a lie. And worse, it would mean letting the next person face the same thing without anyone pushing back. What the officer didn't know, what no one at the station realized, was that this man had spent over a decade inside courtrooms. Not as a defendant, but as someone who helped build cases, who knew the rules of evidence backward and forward, who had trained federal agents on constitutional law. He'd left that world not because he failed, but because he wanted to do something quieter, something closer to the ground. Still, the knowledge was there, coiled beneath his calm exterior like a spring. Back home on bail, he replayed the stop in his head. He remembered the exact time, the angle of the sun, the sound of the officer's boots on the pavement. He filed a public records request for the dashcam and body cam footage. He tracked down the 2 witnesses who'd slowed their cars during the stop, one a nurse heading home from a double shift, the other a college student on his way to pick up his little sister. Both remembered clearly. No aggression, no sudden moves, no resistance. He also studied the officer's history, not out of revenge but out of necessity. He found prior complaints, 3 in the last 2 years, all involving similar language, furtive movements. failure to comply, hostile demeanor. None had led to discipline. All had ended in drop charges or plea deals. Now sitting at his kitchen table with legal pads covered in notes, he began preparing, not just for his own defense, but for something bigger. He wasn't just fighting a false charge. He was testing whether truth could still win in a system that often preferred convenience over justice. The court date was set for 6 weeks out. Plenty of time, people said. But he knew better. Every day mattered. Every detail counted. He wrote out questions he'd ask if he got the chance to cross-examine. He memorized relevant case law. He practiced staying calm, even when imagining the officer's smug expression on the stand. He didn't want a spectacle. He didn't want headlines. He just wanted fairness. The kind of fairness that should be automatic, but too often wasn't. As the days passed, the local news caught wind of the case. Not because he called them, but because someone in the neighborhood posted a blurry clip from a security camera across the street. It showed him standing still, hands up, while the officer shouted. The clip went modestly viral, not with outrage but with quiet disbelief. "That's resisting?" One comment read. He didn't even move. The police department issued a brief statement. All procedures were followed. The matter is under judicial review. But inside the courthouse, things were already shifting. The prosecutor, sensing trouble, tried to delay. The judge denied it. The officer, once confident, started avoiding eye contact during pre-trial meetings. None of that changed what had happened on that quiet street at dusk. But it did show something important. When someone knows the rules and refuses to play along with the lie, the whole game can change. And this man? He wasn't just playing. He was ready to rewrite the rules. The morning of his arraignment, he woke before sunrise. Not because he was nervous, he'd stood in courtrooms too many times to be rattled by procedure, but because his mind wouldn't rest. He made coffee, sat by the window, and watched the neighborhood come alive. A dog walker with 3 leashes tangled around his legs, a teenager on a bike balancing a stack of newspapers, an elderly woman sweeping her porch with slow practice strokes. Ordinary life. The kind he'd almost lost over a lie. At the courthouse, the air smelled like old wood and industrial cleaner. He wore the same clothes he'd worn the day he was pulled over. Clean, simple, nothing flashy. He wanted the judge to see the same man the officer had seen. The same man who hadn't done anything wrong. The charges were read aloud. Obstructing official business, disorderly conduct. Both misdemeanors, but both carrying possible jail time and a permanent mark on his record. The prosecutor, a woman with sharp eyes and a no-nonsense ponytail, laid out the state's version of events. The officer had observed suspicious behavior, issued lawful commands, and the defendant had refused to comply, escalating the situation unnecessarily. When the judge asked how he pleaded, he stood and said, "Not guilty." The public defender leaned over and whispered, "You sure about this? They'll offer probation if you change your mind today." He shook his head. "I'm sure." Back home, the real work began. He knew the system wouldn't hand him justice. He'd have to build it himself, brick by brick. He started by requesting every piece of evidence the prosecution planned to use. Dash cam footage, body cam video, the officer's written report, radio logs, even the maintenance records for the cruiser's camera system. What came back was incomplete. The dashcam file was labeled corrupted. The body cam footage existed, but a full 90 seconds were missing right at the moment he stepped out of the car. The officer's report, meanwhile, read like a script. Subject exited vehicle in an aggressive manner, ignored repeated commands, reached toward waistband in a threatening motion. None of it matched what actually happened. But paperwork has power. Words on a page can shape reality if no one challenges them. He spent nights cross-referencing timestamps, comparing the officer's radio transmissions with the partial video, mapping out exactly where the patrol car had been parked using Google Street View. He tracked down the nurse who'd witnessed the stop. She remembered everything clearly. He didn't move fast, she told him over the phone. He just stood there, like he was trying not to scare anyone. The college student was harder to reach. He'd moved back home for the summer, but after 3 calls, he agreed to talk. The cop was yelling before he even got out of his car, the young man said. "And your guy?" He didn't say a word until he was cuffed. These weren't dramatic revelations, no smoking gun, just truth, spoken plainly by ordinary people who'd seen something wrong and remembered it. Meanwhile, the officer gave interviews, not to major news outlets but to a local talk radio show and a police union newsletter. He described the stop as textbook and the defendant as someone who clearly thought he was above the law. He never mentioned the missing video, never acknowledged the witnesses, just repeated his story like a mantra. The community noticed. A small group of neighbors started gathering outside the courthouse on hearing days, not with signs or chants but with quiet presence. They brought coffee. They held doors. They made it known. This man wasn't alone. Still, the pressure mounted. His employer, a nonprofit legal aid group, supported him, but clients began to whisper. Is he in trouble with the law? Can he still represent us? He didn't blame them. Trust is fragile. Once cracked, it takes time to rebuild, even when you've done nothing wrong. One evening, sitting at his kitchen table with legal pads spread like a battlefield map, he received an email from an old colleague, a former judge he'd worked with years ago. If you're going to do this, the message read, do it right. Don't just defend yourself. Expose the pattern. That night, he filed a motion, not just to dismiss the charges, but to compel the police department to release all internal affairs complaints against the officer from the past 5 years. He cited public interest. He cited due process. He cited the fact that false reports weren't just mistakes. They were violations of the public trust. The department fought it, called it a fishing expedition, said it would chill officer morale. But the judge, after reviewing the partial footage and the witness statements, granted the motion, partially. They'd have to turn over redacted summaries of prior complaints. What came back was telling. 3 complaints in 2 years. All involved similar language: non-compliance, evasive behavior, hostile attitude. In 2 cases, charges were dropped when video contradicted the officer's account. In the third, the defendant took a plea deal to avoid jail. It wasn't proof of guilt in his case, but it was proof of a habit. And habits in court can crack open the door to doubt. As the trial date neared, the prosecutor called with a new offer. Time served, no record, just a fine. It's the best we can do, she said, her voice softer now. He thanked her but said no, because this wasn't just about him anymore. It was about the next person pulled over for no reason. The next person told to just take the deal. The next person who didn't have the knowledge, the time, or the courage to say no. He began preparing to represent himself. Not because he wanted to, but because he knew no one else would fight as hard. He studied courtroom procedure, practiced objecting without sounding aggressive, rehearsed how to question a witness without leading them. He wanted to be precise, not performative. His friends worried. You're not a criminal defense lawyer, one said gently. This is different. I know the law, he replied, and I know what happened. The night before jury selection, he didn't sleep much. Not from fear, but from clarity. He kept thinking about his father, who'd been stopped dozens of times growing up, always polite, always compliant, always let go with a warning, and always shaken afterward. You learn to carry yourself like you're on trial just walking down the street, his dad used to say. Now he really was on trial, but this time he had more than just dignity to defend. He had facts, evidence, and a quiet, unshakable belief that truth, if spoken clearly enough, could still matter. When he walked into the courtroom the next morning, he didn't look like a man fighting for his freedom. He looked like a man who'd already decided what kind of world he wanted to live in, and was willing to stand in it even if he stood alone. But he wasn't alone. Not really. Every person who'd spoken up, every neighbor who'd shown up, every stranger who'd shared the security camera clip, they were all part of this too, and soon, the whole room would hear what really happened on that quiet street at dusk. Not the story the officer told, but the one the truth remembered. The courtroom was quieter than he expected. Not silent, just hushed, like people holding their breath without realizing it. Sunlight slanted through the high windows, catching dust motes in the air. The jury sat in neat rows, faces unreadable. Some looked tired, others curious. None looked ready to decide a man's future before hearing both sides. The prosecutor called the officer first. He walked in with his uniform crisp, badge gleaming, posture straight. He took the stand like he belonged there, as if truth naturally followed him into every room. Under gentle questioning, he told his story again. The suspicious lane change, the refusal to comply, the sudden movement toward his waistband. He spoke with calm certainty, the kind that sounds like honesty if you don't look too closely. The prosecutor finished with a satisfied nod. Your witness. A murmur rippled through the room. Most people expected the defense to call someone else, a lawyer, an expert, maybe one of the witnesses. But instead the man stood. Not dramatically. Just rose from his chair, smoothed his jacket, and walked to the podium. I'll be representing myself, Your Honor, he said, voice steady. The judge gave a small nod. You understand the risks? I do. He turned to face the officer. No anger in his eyes. No theatrics. Just focus. Officer, he began. You testified that I made a sudden movement toward my waistband when I got out of the car. Is that correct? Yes. Can you describe that movement for the jury? How fast was it? Which hand did I use? Did I bend at the waist or just reach down? The officer shifted slightly. It was quick left hand. I didn't see exactly. You didn't see exactly, he repeated gently. But you reported it as a clear threat in your written statement. Correct? Well, in the moment, he cut in, not harshly but firmly. You also radioed dispatch. Do you remember what you said? Before the officer could answer, he turned to the judge. Your Honor, may I play the audio from the police radio log time-stamped 6:12 p.m., the moment I exited the vehicle? The judge allowed it. A scratchy voice filled the room, the officer's own voice from that evening. Suspect out of vehicle. Standing still. Hands visible. The courtroom went still. He let the silence hang for a beat. Then, so at 6:12 p.m., you told dispatch I was standing still with my hands visible. But in your report filed 2 hours later, you wrote that I made a sudden threatening movement. Which one is true? The officer's jaw tightened. I may have updated my assessment after reviewing the situation. After reviewing it? In your head? Or after deciding you needed a reason to justify the arrest? I didn't need a reason, the officer snapped. He was non-compliant. Non-compliant how? Did I refuse to show my license? No. Did I swear at you? No. Did I move before you told me to step out of the car? No, but then what exactly was non-compliant about me standing still after you ordered me out? The officer glanced at the prosecutor, who gave a tiny shake of her head. Don't guess, don't speculate. I felt threatened, he finally said. Felt, the man repeated. Not saw, not heard, felt. And based on that feeling, you arrested me, cuffed me, and charged me with crimes I didn't commit. I followed procedure. Did you? He turned to the judge again. May I introduce Exhibit D, the department's own policy manual, Section 4.2 on use of force and arrest justification? Approved. He held up a printed page. It says here that an officer must have reasonable articulable suspicion of criminal activity before detaining someone, and probable cause before making an arrest. Did you have either when you pulled me over for a lane change? I observed erratic driving. Erratic? I changed lanes once, signaled, stayed within the lines. The dashcam shows that, except of course the dashcam file your department says is corrupted. Funny how that only happened in my case. The officer's face flushed. That's not my fault. Maybe not. But it is your fault that your body cam missed 90 seconds of the most critical part of the stop. The part where I supposedly resisted. Isn't it standard procedure to activate the camera before initiating a stop? Yes, but so why was it off for those 90 seconds? I don't know. Technical issue. 3 other stops you conducted that week had full footage. Only mine is missing. That's quite a coincidence, the prosecutor objected. Speculation. And the judge sustained it. But the seed was planted. The jury had heard it. He moved on, calm, methodical. He played the partial body cam video, the part that existed. It showed him stepping out slowly, hands raised. The officer shouting, "Stop resisting," while he stood perfectly still. Do you see me resisting in that clip? He asked the officer. It's edited. By whom? The police department released it. Are you saying your own department edited it to make you look bad? The officer didn't answer. Then came the witnesses. The nurse described what she saw from her car. He didn't move fast. He didn't argue. He just waited. The college student added, the cop was already yelling before he got out of his cruiser. The other guy didn't say a word until the cuffs were on. Each statement chipped. away at the officer's version like water on stone. But the real turning point came when he asked about the prior complaints. The prosecutor objected immediately. Irrelevant. Character evidence, he countered. It's not about character. It's about pattern and credibility. If an officer has repeatedly filed reports contradicted by evidence, that goes to whether this jury should believe him today. The judge considered it. Then, limited admissibility. You may ask about the existence of prior complaints, but not the details. He nodded. Officer, have you had other complaints filed against you for inaccurate reporting? Yes, the officer muttered. How many in the last 2 years? 3. And in how many of those were charges dropped or dismissed after video evidence surfaced? 2. So twice before your written account didn't match what the cameras showed. And now in my case, the camera footage is missing right when your story gets dramatic. Do you see why the jury might find that troubling? The officer stared straight ahead. I did my job. No, the man said softly. You told a story, and you expected no one to check. He sat down. No grand finish. No pointing finger. Just the quiet weight of facts laid bare. The prosecutor tried to recover on redirect, asking the officer about his training, his years of service, his commitment to public safety. He answered, but his voice lacked its earlier certainty. He kept glancing at the jury as if searching for forgiveness he hadn't asked for. When court adjourned for the day, people lingered in the hallway. Not talking loudly, just standing processing. A juror dropped a pen and someone picked it up for her without a word. The air felt different, lighter somehow, like something heavy had been lifted. That night, he didn't celebrate. He ate a simple dinner, reviewed his notes, and called his mother. She didn't say much. Just, I'm proud of you. And for the first time in weeks, he let himself feel tired because tomorrow the jury would decide. Not just about a traffic stop, but about who gets believed, who gets the benefit of the doubt, and whether truth carefully spoken can still win in a room full of power. He went to bed hoping they'd listened, not to him but to the silence between the lies. The jury came back faster than anyone expected. Just 2 hours after closing arguments ended, the foreperson knocked on the judge's chamber door. Courtroom staff scrambled to call the lawyers, though in this case, one of them was still sitting in the defendant's chair, quietly reviewing his notes as if the verdict hadn't already begun echoing in his chest. When everyone was seated, the judge asked the foreperson to read the decision. The room held its breath. On the charge of obstructing official business, not guilty, a pause. Then, on the charge of disorderly conduct, not guilty, no cheers, no outbursts. Just a collective exhale, like a room full of people finally remembering how to breathe. The judge thanked the jury, dismissed them, and turned to the man. You're free to go. He nodded, stood, and walked out without looking back. Not out of arrogance, but because there was nothing left to prove in that room. The truth had spoken, and for once it had been heard. Outside, a small crowd waited. Not a mob, not a protest, just neighbors, a few strangers who'd followed the case online, and 2 reporters from the local paper. They didn't swarm him. They just stood there, some smiling faintly, others with tears in their eyes. One woman handed him a thermos of tea. You looked like you could use it, she said. He thanked her, took a sip, and kept walking. But freedom didn't feel like celebration. It felt like relief mixed with exhaustion. He'd won the case, yes, but the cost had been steep. He'd missed weeks of work. His savings had drained paying for transcripts, filing fees, and expert consultants. Online anonymous accounts had called him a thug playing lawyer and worse. His landlord had asked if he was still in legal trouble, as if guilt lingered even after a jury said otherwise. Still, he didn't regret it. Because now the officer's story was public. The missing footage, the contradictory radio log, the pattern of complaints. None of it could be buried again. Within days, the police department announced an internal review. Not because they wanted to, but because the mayor's office had received dozens of calls from concerned citizens. Local news outlets, once hesitant to question law enforcement, began digging. They found 2 more cases where the same officer's reports didn't match available video. In one, a teenager had been charged with assault for lunging at the officer, except the store security tape showed the teen backing. Away with his hands up, the department suspended the officer with pay pending investigation. It wasn't justice, not fully, but it was accountability, however slow and reluctant. Meanwhile, the man returned to his life. He went back to his job helping low-income clients navigate housing disputes and unfair evictions. But something had shifted. People looked at him differently, not with pity or suspicion, but with quiet respect. A young intern asked if he'd consider mentoring law students. A community center invited him to speak at a town hall about knowing your rights during police stops. At first, he said no. He wasn't looking for a platform. He'd only wanted to clear his name. But then he remembered the fear in the eyes of the college student who'd witnessed his arrest. The way the young man had whispered, "I didn't know I could say something." And the nurse who'd said, "I almost drove past because I didn't want trouble." That's when he changed his mind. He started hosting free Saturday workshops at the local library. No cameras, no press, just folding chairs, a whiteboard, and clear, plain explanations. If you're pulled over, keep your hands visible. You don't have to consent to a search. You can record the stop, as long as you're not interfering. He taught people how to file public records requests, how to document encounters, how to find legal aid without spending a fortune. Attendance grew. Not because he was famous, but because he spoke like someone who'd been there, and come out the other side with both truth and dignity intact. One afternoon, a teenager showed up alone, hoodie pulled low, eyes darting. After the session, he lingered. "What if they don't believe you?" he asked quietly. "Even if you're telling the truth?" The man didn't offer empty reassurance. "Sometimes they won't," he said. "But that doesn't mean you stay silent. It means you prepare. You gather proof. You find people who'll stand with you. And if the system fails you once, you use that experience to protect someone else next time." The teen nodded, tucked the handout into his pocket, and left without another word. But the man knew. He'd been heard. Back home that evening, he scrolled through emails. One stood out, a message from a woman in another state. Her brother had been arrested under similar circumstances. False report, missing footage, pressure to plead. She'd read about the case online. "Is there any way you could point me to resources?" She wrote, "We don't have money for a lawyer, but we can't just accept this." He spent the next hour replying, listing legal aid groups, sample motions, even a template for requesting body cam footage. He didn't know if it would help, but he remembered how alone he'd felt at the start, and he couldn't leave her in that silence. The victory in court hadn't fixed the system. Cops still lied. Cameras still malfunctioned. Innocent people still took plea deals out of fear. But now at least there was proof that fighting back could work, not with anger, but with knowledge, patience, and stubborn truth. He never gave interviews to national news, never posted about the case on social media. But his story spread anyway, through community meetings, legal forums, late-night conversations between parents warning their kids how to stay safe. And slowly, quietly, things began to shift. The city council formed a civilian oversight committee. The police union agreed to mandatory de-escalation training. The district attorney's office started reviewing old cases involving the same officer. None of it happened because one man won a trial. It happened because he refused to let a lie stand, and showed others how to do the same. One evening, months later, he sat on his porch watching fireflies blink in the dusk. His phone buzzed. It was a text from the public defender who'd urged him to take the plea deal. "You were right," it read. "I'm changing how I advise my clients now. Thank you." He didn't reply right away, just sat there listening to the crickets, feeling the weight of everything that had passed and everything that might still come. He hadn't set out to be a symbol. He'd just wanted to go home that night without being turned into a criminal for doing nothing wrong. But sometimes doing the right thing, even quietly, ripples farther than you ever imagined. A year after the verdict, the city council chamber was packed, not with reporters or activists, but with ordinary people. Bus drivers, teachers, small business owners, retirees. They'd come for a public hearing on proposed changes to police reporting procedures. At the center of the room, a new policy draft sat on every chair, requiring all body cams to be activated before any traffic stop, mandating immediate preservation of footage in cases involving arrests, and creating an independent review panel for officer complaints. No one mentioned his name during the meeting, but everyone knew his story had started it all. He wasn't there that night. He rarely attended official events anymore. Instead, he was across town in a cramped community center basement, sitting at a folding table with a nervous teenager who'd just been cited for loitering outside a convenience store despite having bought a soda and been waiting for his ride. "You didn't do anything wrong," he said gently, sliding a printed sheet across the table. "But they wrote it like you did. So now we fix it." The teen, shoulders hunched, stared at the paper like it might bite him. "How?" "First, we request the store's security footage. Then we file a motion to dismiss based on lack of evidence. And we write a letter to the police chief, calm, factual, asking why an officer would cite someone for standing still after making a legal purchase." He didn't promise it would work, but he promised the teen wouldn't face it alone. This had become his rhythm now. Not courtrooms, but classrooms of a different kind. Every Saturday he taught a 2-hour session called Know Your Rights, Know the Process. No jargon. No legalese. Just clear, practical steps. How to stay safe during a stop. How to document encounters. How to navigate the system without a lawyer if you had to. Attendance had grown from 5 people to over 30 with a waiting list. He never charged a dime. What surprised him most wasn't the turnout. It was the quiet transformations. The single mother who used what she learned to challenge a wrongful eviction. The delivery driver who recorded a baseless stop and later saw the officer reprimanded. The high schooler who helped a friend file a public records request after a school resource officer confiscated his phone without cause. Change wasn't happening in headlines. It was happening in living rooms, bus stops, and text threads where someone shared a template or a tip. And he was glad to be part of it, not as a hero but as a guide. The officer who'd lied about him? He'd been reassigned to desk duty after the internal investigation confirmed a pattern of inaccurate reporting. No criminal charges, departmental discipline rarely went that far, but his credibility was shot. Other officers stopped backing his stories in court. Prosecutors grew cautious about taking his word without video. It wasn't poetic justice, but it was real-world consequence, and that, the man had come to believe, was often enough. One rainy afternoon, he received a thick envelope in the mail. Inside were printed pages from a state legislative committee, draft language for a statewide Transparency in Policing Act, modeled partly on the reforms his city had adopted. A handwritten note was clipped to the front. "Your case was cited 3 times in our hearings. Thank you for showing us what's possible." He tucked the note into his desk drawer, not for pride but as a reminder. Truth doesn't always win in a single moment, but it can plant seeds that grow long after the cameras leave. He still worked his day job, helping tenants fight unfair evictions, guiding families through guardianship paperwork, translating legal forms into plain English. But now he also spent evenings reviewing draft letters from workshop attendees, offering quiet advice over coffee or simply listening when someone needed to talk about being treated like a suspect for no reason. He never sought fame. In fact, he turned down every interview request after the trial. "This isn't about me," he'd say. "It's about what happens next." And what happened next was this. More people began asking questions. More people demanded to see footage. More people said, "I'd like to speak to a lawyer," instead of signing whatever was put in front of them. Not because they'd become radicals, but because they'd learned that the system responds to clarity, not just compliance. One evening, as he packed up his materials after a workshop, a woman approached. She looked to be in her 60s, wearing a floral dress and sensible shoes. She held out a small jar of homemade jam. "My grandson told me about your class," she said. "He used what you taught to get a false citation thrown out. Said you treated him like he mattered. He accepted the jar, touched. He did the work. I just showed him the door," she smiled. "Sometimes that's the hardest part, knowing there is a door." He walked home that night under a sky full of stars, the jar tucked carefully in his bag. The city felt different. Not perfect, not healed, but awake in a new way. People were paying attention, not with rage, but with resolve. Months later, he got a call from a law school dean. They wanted to create a fellowship in community legal empowerment, and they wanted him to help design it. He agreed on one condition. The program would prioritize students from neighborhoods most affected by over-policing, and every fellow would spend half their time teaching, not just studying. "It's not enough to know the law," he told the dean. "You have to give it back." Now, on most weekday mornings, you could find him in a quiet corner of the public library, meeting with a new group of fellows. They brought him case files, draft lesson plans, questions about ethics and strategy. He listened more than he spoke, but when he did, his words carried weight, not because of what he'd survived, but because of what he'd chosen to build afterward. The story never ended with a gavel or a headline. It ended, as real stories do, in small acts of courage repeated over time. A teenager learning his rights, a neighbor sharing a template, a city changing its rules because enough people said, "This isn't right." And in the middle of it all was a man who'd simply refused to let a lie stand, and in doing so, gave others the tools to stand tall too. He didn't need a statue. He didn't need a spotlight. He just needed to keep showing up, one person at a time, proving that fairness isn't a gift handed down from above. It's something we build together, quietly, patiently, every single day.